Welcome to StarTalks powered by Advotalks. I am Siraj, and today we have with us our esteemed guest, Ms. Ayushi Dwivedi. Ms. Ayushi is a legal expert in mergers and acquisitions, contract drafting, intellectual property rights management. She has been helping businesses navigate complex legal challenges and achieve their goals. She practices in the areas of contract reviewing and negotiation, corporate governance, mergers and acquisitions, securities regulation, compliance, and dispute resolution. She is a consultant for US, UK, and Canadian laws. She has been writing and speaking at various conferences and publishing platforms on topics like review on the Uniform Civil Code, unveiling the startup funding strategies and choices for success, the artificial intelligence in genetics and biotech research. Today, she would like to spend time with us to understand on the topic beyond the balance sheet, unveiling mergers and acquisition, intellectual property rights, and mastering the contract drafting. I should admit that I'm quite excited to host her. With that, I warmly welcome her to our talk show, StarTalks, powered by Advotalks.
Yeah, thank you so much, Siraj, for this beautiful introduction. I'm pretty much overwhelmed with the introduction, and thanks to the forum of Advotalks for inviting me as a guest speaker. And I would be quite happy to help you out with the understanding that you are looking for around M&E, intellectual property rights management, and contract drafting. Thank you so much for
Yeah.
having me.
I'm pretty much sure that this is going to be an exciting discussion for us at Advotalks. With that, let me start with a fundamental understanding on, how have you drawn your interest towards the technical subject, intellectual property rights, and the mergers and acquisitions, and the contract drafting in the first place, Aishi?
Yeah, I was drawn to IPR, M&A, and contract drafting because of my passion for innovation and technology and all the creativity behind all this. So I think IPR is essential for any business to succeed in the global market and to protect their unique ideas and products. And I also love the challenge and complexity of M&A, where I can help clients achieve their business goals and objectives through various legal, financial, and strategic aspects. So, contract drafting is another skill that I enjoy, as it requires me to draft clear, concise, and comprehensive contracts that reflect the party's intention and protect their interests. So this is one of the key skills that every lawyer must have, and this is the only medium through which they can convey their party's intention properly. So yeah, that's it.
Yeah, like
Siraj.
there are multiple aspects on the financial and strategic as well as the legal, as you mentioned, and the analytical as well as the drafting skills are something that these are the combination basically. Good to know about you, Aishi. We will go ahead and then try to understand. Have you been involved in any recent mergers and acquisition deals? If so, what were the primary challenges, related to the intellectual property rights and the contract drafting and the negotiation as such?
Yeah, I have worked on a decent number of M&A deals in the past few years and in different sectors and jurisdictions. So there are a lot of changes, challenges in IP rights and contracts, and few of them I would like to mention here is doing a thorough IP diligence to check and evaluate the target's IP assets and liabilities like patents, trademarks, copyrights, trade secrets, licenses, litigations, and etc. etc. Like if there is any ongoing disputes is there between the parties or from the seller side or on the buyer side. So these needs to get checked before it, and also analyzing the impact of the M&A transaction on the target IP rights and obligations like ownership, transfer, assignment, licensing, enforcement. There are multiple factors to analyze. Then it's, yeah, definitely the crucial aspect of negotiating and drafting the IP related clauses and provisions in the M&A agreement is one of the key aspects that every party looks for. And like It includes representations and warranty clauses, indemnities, covenants, closing conditions, etc. And these such clauses are actually advised and properly drafted by the expert, and in the supervision of experts is very much beneficial for the other parties as well, who are included in the transaction. And handling the post closing integration and transition of the IP portfolio, like registration, maintenance, renewal, etc. These are such things that actually concludes the deal. So even after the deal has been made and all the crucial aspects has been done, so post closing handling is also much required.
Okay, so meaning
Yeah,
like
that's it,
the
Siraj.
lot of aspects of like the transfer and the assignments, as these are having the impact on M&A transaction, as well as
Yeah.
you have also brought in the technical terms onto covenants and the warranties, installing some warranties and the clauses. I'm quite sure that the viewers are going to get benefit out of these insights that you're bringing. We will move to the next question, where I want you to help us understand what are the biggest concerns regarding the potential legal issues that happen, in the mergers and acquisitions transactions.
Yeah, there actually, if we talk about, there are not just we are just not limited to some aspects, but most of the aspects are actually concerns. Things to concern about.
Right.
So biggest concern to here to mention is like you have to go through regulatory compliances and approval. Like you can say antitrust approval for investment, tax environment. You have to look into for the labor laws if you're going to multi-country transaction. And there is a need of disclosure and discovery of material information like financial statements, business plans, like what I've mentioned earlier, litigation or any ongoing disputes is there, or whatever the contracts the parties is having, like whatever their clients are. So these needs to get checked properly. This is one of it can be the biggest concern for the party in the deal. And allocation and mitigation of risk and liabilities, like is there any breaches, is there any defaults, is there any claims that is not yet resolved, or is there any disputes or any of the other legal liabilities there in any of the parties? So these needs to get checked.
Right.
And yeah, definitely there is an enforcement and dispute resolution mechanism will be followed by, or there is any ongoing one, like if it is any arbitration, litigation, injunctions, or any damages against the party. So these needs to get checked, and it is the biggest concern for the parties involved in the M&A transaction. Yeah,
Okay, so there are like
that's it.
multiple aspects like the regulatory compliance, and you have this dispute resolution enforcement, and subsequently stuff related to the injunctions and the damages. A lot of aspects are there. I do see that the skill and the level of commitment towards the practice within the IPR as well as the M&A is too huge and high from the practitioners as such. With that, I wanted to know little more from you, like how significant is the valuation of an intellectual property rights, and what is the diligence that in enabling the parties to arrive at a fair deal value during the M&A negotiations. Like for our viewers and the practitioners around aspirants, what are the tools and the resources that you do recommend to kind of provide a fair a deal value during such M&A negotiations?
Yeah, IP valuation and diligence are very important in enabling parties to arrive at a fair deal value during M&A negotiation, as they help to determine the quality, quantity, and value of the target's IP assets and liabilities, that which can directly affect the overall valuation of the target and, of course, the deal price. So these valuation and diligence also helps identifying the opportunities, synergies, and challenges that involved in the M&A transaction, which affects the strategic fit and rationality of the deal. These definitely helps you minimize the risk involved and uncertainties and contingencies of the M&A transaction, which ultimately affects the deal structure in terms if it is not discovered yet. So these checks needs to be done during or before the transaction. And for these evaluation and diligence process to properly run and to make it happen, I would recommend some resources. Like how you can do it is, you can actually opt for the IP valuation methods and models. That includes the income, cost, market, and option approaches, which provides different perspectives and estimates of the IP value. And you can also take the help of the IP valuation experts and consultants. That includes accountants, appraisers, analysts, who can help you provide professional and independent opinions and reports on the IP value. So also there are a lot of international organizations
Right.
that they provide a proper IP due diligence checklists and templates where you can refer to them, and these are especially provided by the World Intellectual Property Organization. We people used to call it WIPO.
Typo.
Uh, AIPPI, that's also another international association for the protection of intellectual property, and American Bar Association, which provide guidance and best practices for conducting IP due diligence. So we can refer to these checklists and templates and methodologies to properly execute the whole IP valuation and due diligence process.
Okay, there are like
Yeah.
the international institutes like WIPO and the AIPPI, which you mentioned. These are coming up with certain, templates, which can be kind of,
Yeah.
starting point to kind of, ensure that quality and the value of, the assets and liabilities that you arrive out of the target's IP.
Mhm.
Thanks for bringing those aspects, Ayushi. Dwelling further, like I want you to give us an understanding on what risks can pre-existing IP infringements pose in an M&A deal, and how can the legal teams mitigate them? And are you seeing more such cases now in any chance?
Yeah. Pre-existing IP infringements can seriously create a big problems in an M&A deal. Like all the fair deal value, when we talk about these stuff, it all already includes a whole valuation of the deal. So it can cause lowering the value and quality of the target's IP assets, which can affect how much the deal is worth and what terms are agreed upon, and putting the target and the acquirer at risk of facing legal actions like cost, like being sued, fined, or order to stop using the IP assets. So making it harder to integrate and operate the merged entity, like having to limit or change how the IP assets are used, developed, or marketed. So in managing all such things and to avoid such legal issues, legal teams definitely plays a very big role in that. Legal teams can help you reduce these problems by doing a careful IP due diligence to find out and evaluate the extent and nature of the pre-existing IP infringements, like by looking up the relevant IP databases that is already provided in various organizational websites and registries. You can go through They can go through the registries and the publication, and they can even go through the relevant IP documents and agreements and litigation. They can help you out looking forward to the things that there are certain similarities related to your IP assets is present there already in the market or not. So they also helps you in negotiating and drafting the IP related clauses and provision in the M&A agreement to assign and deal with the responsibility and liability for the pre-existing IP infringements, like by making suitable representations and warranties, because these such clauses are very much crucial from the perspective of the parties involved. Indemnity clauses, covenants, and closing condition that I've already mentioned earlier. So these are the very important and crucial part of the agreement. So taking the post-closing action, again, I would like to mention that in remedies to solve the prevent pre-existing IP infringements, like by getting licenses, assignments, consents or waivers, or by starting or defending IP litigation or in arbitration. These all such things that can actually break or make your deal. So likewise, in this thing, IP team, legal team helps a lot. to the parties. And yeah, definitely I'm seeing more such cases now, because as the IP environment is becoming more complicated and competitive, and the IP enforcement is becoming more active and aggressive these days. So especially in the new markets and technologies, I am definitely seeing more such cases these days.
Absolutely, absolutely.
Yeah,
I
that's
agree with you that, the IP landscape is kind of, becoming more and more complex, as you mentioned. And especially when it comes to, coming up with the IP related clauses and making the appropriate representations and warranties, as you mentioned, is also, kind of, something that the legal teams should be, adopt to mitigate the risk. There have been multiple things that you have mentioned. With that, it's quite a challenge to kind of, effectively manage the competing interests between the buyer and the seller during the contract negotiations. I mean, it's a skill for the, drafters. I wanted to understand from you, Ayushi, see, what are the key clauses and the provisions that you do prioritize when negotiating a merger and acquisition contract?
Yeah, as you said, I mean, definitely, like to manage competing interests between buyer and seller is really a task for the legal professional and the team, because it's very difficult to understand what are their expectations. So I would suggest like to go through the process of knowing the goals, their expectations and motivations of each party, and finding the common ground, like the possible areas of conflict, maybe in future or in during this deal itself. So, and you should like what I would suggest is that the legal profession must be clear in whatever they are talking to their clients. They must be respectful and constructively with each party. So, and answering their concerns and questions in a quick and honest way will really helps you out. So, and also finding the balance and compromise between each party and trying to create a value, and of course achieving a win-win situation, a win-win outcome for both the party is very much essential. So these aspects, a legal professional and the team who is actually involved in the whole transaction process needs to take care of such things, so that they can have a proper and smooth process, and also a trust build up between the client and the professional. And yeah, of course, like key clauses and provision that I focus on when negotiating M&A contracts are like the purchase price, definitely, and the payment terms, like how much, what currency, and how, when, and how to adjust the price. So these are the clauses that needs to get focused on, the closing conditions and the termination rights, like what approvals, concerns required, and waivers are needed, what events can end the agreement, and the representation and warranties, like I used to mention these terms again and again.
Right.
And the indemnities plays a crucial role, as what statements and assurance are made by each party about the target and the transaction, and what obligations and liabilities are taken by each party in case of any breaches or claims, and the covenants and the post closing obligations, like what promises and commitments are made by each party during and after the transaction, like how to run the business, how to cooperate, and how to help after the deal. So these such things needs to be taken care of and should be there in the agreement itself for the smooth process
Right, like
without
you
any
said, the
disputes.
balancing the trade-offs and the concessions is something that, the role of person who is into the M&A deals as such. Thanks for bringing a lot of aspects on how clear the communication should be, and choosing the right clauses, the key clauses in the contract, as well as you have brought in a very pretty much, still there is a room for understanding from my side on the post-closing obligations and stuff like that. Aishi, what strategies do you employ to mitigate the post-deal disputes, especially arising from the contractual ambiguities?
Yeah, needs to put a lot of brains here for that. Like some of the strategies that I use to reduce post-deal disputes arising from contractual ambiguities are generally like writing clear, concise, and complete contracts that shows the parties' intentions and expectations, and avoid any unclear, ambiguous, or inconsistent terms and provision. Because these days, what I'm facing is clients wants to put general terms into the contract
Right.
instead of being specific. specific, because they think that like if we put something general in the contract, then we will not be the people who are be responsible for any liabilities in the future. So during the dispute, we can actually twist and turn the judges or any of the arbitrator or mediator. So that's for that reason they keep the clauses general. But to be very honest, if it comes to the dispute, you will be losing money, you will be losing the integrity, you will be losing the goodwill once you lose the case. So it is definitely very important to put a clear, concise, and complete contract. And adding dispute resolution mechanism and procedure in the contract, like mediation, arbitration, litigation, stating the applicable laws, jurisdiction, venue for resolving any disputes, should be written specifically, because at the end of the day, when there is a dispute, you will not be struggling in finding which arbitration we should choose for and which dispute resolution mechanism we will be going. So definitely it will be there when you are actually in a cordial relationship with the other party. So, and definitely keeping good communication and relationship with the other party is very much important. Like trying to resolve any, trying always try to solve any issues or disagreements in a friendly and timely way before they become formal disputes, and it can really helps you out in in throughout the deal also, and even after the deal.
Right, right. Quite a good inputs
Yeah.
on the strategies for mitigating the post-deal disputes, from these ambiguities, especially. And what advice would you give to individuals or companies who are entering into the mergers and acquisitions kind of a transactions, and regarding the intellectual property rights and the contract negotiation, Ayushi?
Yeah, my advice would be for them is to carry out a careful IP due diligence to find out and evaluate the target's IP assets and liabilities, and analyze the impact of the transaction of on the IP rights and obligations, and try to negotiate and draft the IP related clauses and provisions in a M&A agreement properly, so that they can protect and increase the value of the IP assets, and to assign and reduce the risks and liabilities of the IP issues. That should be made your priority. And of course, the post closing actions and remedies should be there properly mentioned in the agreement, and also discussed between the parties before signing the deal. Can prevent the pre-existing IP infringements, like by getting licenses, assignments, concerns, waivers, or starting or defending any litigation or disputes ongoing, or any of the arbitration matter is there pending, that much needed, some much needed part that
Yeah.
should be resolved before. And of course, definitely getting an professional and expert advice and help from qualified lawyers, accountants, appraisers, or can be a consultant who can have who have experience and expertise in IP and M&A matters, will definitely help you help you save a lot of money
Yeah,
and stress also.
that's a great takeaway for the clients, on the M&A aspects.
Yeah.
Ayushi, let's wind up with one last question. Like, are there any emerging trends or challenges that you foresee in the legal landscape of the mergers and acquisitions, particularly related to the intellectual property rights and the contracts?
Yeah, you can see that there is a boom in technology these
Yep.
days. So new trends and challenges, what I have seen and I'm feeling these days in the legal field of M&A, especially related to IP and contracts, the growing role and difficulty of IP in M&A deals, especially in the technology, media, and entertainment sectors, uh, where IP is the main source and factor of value and innovation. And definitely the increased cross-border and multi-country nature of M&A deals. Like these days, majority of the M&A deals are multi-country only. Though I have not seen such any deals till the date where this includes the two companies merging and acquiring the same company in the same country. So definitely there are a lot of cross-border and multi-country deals, and which brings a lot of legal and regulatory problems and doubts, like coordination and implementation of IP and contract law, the approval and permission of antitrust and foreign investment authorities, and the tax and currency issues for sure. So the rising rivalry and lawsuits in the IP and M&A markets which raise the risk and cost of IP conflicts and complaints, can include the violation, invalidity, and even the theft of IP rights. So this is like break or end of IP or MLA contracts. So to protect that, you should be very careful. And the injunctions are some of the factors that needs to be checked and smoothly avoided, I would suggest. And it is really needed a task for the legal professionals or any of the parties involved altogether, that they need to take care of such aspects before jumping into any of the deals.
Right, as
That's
you
it.
rightly mentioned, like the technology, with the advent of the technology, many sectors, including the media and the entertainment, I guess there are a lots and lots of things happening around the M&A and the IP infringements. And as you also came up with this analysis of, most of the disputes are actually of cross border or the cross jurisdiction in nature. I think these are certainly great inputs for our viewers out there. Actually, that brings us to the end of this great insightful conversation with you. Thanks for helping us and our audience understand the various aspects of the mergers and acquisitions, the intellectual property rights related laws, and an effective contract drafting. We appreciate your taking time, and thanks a lot again.
Yeah, and thank you so much to you and the team. It is quite positive and insightful discussion, to be honest, and hope I was able to address the queries that you have raised on the M&A, IPR laws, and the contract drafting practices. And I, from the bottom of my heart, thank the team of Advotalks and for calling me out here on to talk on this and become the medium to help other people and audience who's watching it. So thank you so much for
Absolutely,
having me.
absolutely. It is definitely a key takeaway for our viewers and the audience. Thanks a lot, Ayushi. So that's about today's episode with Advocate Ayushi Dwivedi, which brings a lot of insights on the loss of merger and acquisition, contract negotiation, and the intellectual property rights management. We hope the conversation was knowledgeable. For more updates and information on legal concepts, please visit our website www.advotalks.com, and don't forget to like, share, and subscribe to our YouTube channel, Advotalks.